Okay, part 2, day 6, cross-examination of the forensic doctor.
Good afternoon. It's still morning. Sorry, it's been a long day. Doctor, talking about generally stippling, stifling, comes if this, I'm holding up the pointer, the back end of the pointer, the thick end, the barrel of the gun. Here, do we have agreement with that?
Yes.
If this gun fires a projectile, the first thing that comes out, and I'm not saying in order, but what would show nearness is soot stippling, correct?
Correct.
And then further out would be gunpowder stippling.
Yes, soot and then gunpowder.
Okay, and in the soot stippling, it has to be, generally speaking, as you said, either in contact or within a foot.
Yes, it's within a few inches. It's very close.
Okay, and when you looked at the state's exhibit, you said it was either very close or in contact, and we're talking about the hand wound.
Yes, it could be within that range. So it could have been in contact.
Okay, and as I said, if this is the barrel of the gun, this is my left hand, the barrel of the gun had to be somewhere in this area, correct?
That's correct.
Now, the soot stippling, and I'm pointing with the pointer to my baby finger, there is no soot stippling here, correct?
I believe that's correct, yes.
Okay. The bulk of it starts between what would be the ring and commonly referred to as middle finger?
Yes.
Okay, so that means the barrel of the gun, if not touching, would have been like this.
It's in that location. That's correct.
So,
Great point. I wish he would follow up. Like, if a hand was grabbing the barrel, that would be consistent with those injuries. And let the prosecution object.
that hand was over the barrel of Mr. Rittenhouse's gun when his hand was shot.
That makes sense.
Okay, and the bullet goes into the fingers and then out through here. And I'm showing the fat part of the between my index and thumb.
Yes, the exit is to the index finger, but it's on the back of the lateral side of that finger, yes.
And is it 105, please? On the screen. Bomb's hand,
His left hand,
left
correct.
hand, and you took that photograph, correct?
Yes.
Circle on here to the best of your ability where the soot starts.
Yeah.
Okay, can you draw a line off of there into where it can be seen and then just put your initials? Thank you. And you put the circle on the ring finger, correct?
Correct.
Leaving the baby finger uncircled and blank, correct?
Correct. I don't
Because
see any.
you don't see any soot there, right?
Correct.
Would move Exhibit 105 into evidence. Objection?
Yeah.
You would ask to publish it to the jury.
Already on the screen. Okay, go ahead.
Okay, so now he got that in evidence, and we have a doctor circling where the burn marks, where the injury's at, which is pretty good, because the jury's going to remember that.
It's a dynamic situation, correct?
Correct.
And the bomb, which is captured partially on video, is a dynamic situation, correct?
Correct.
And
I think he said Rottenbaum's actions was involved in a dynamic situation, meaning it was rapidly changing.
if the furthest he was away with the stifling that you see in the wounds was 4 feet and closing, that goes very quickly, correct? If someone's running at you?
Yes.
Okay. And 4 feet, correct me if I'm wrong, is about from me to you away.
That's about correct.
And if I had my hands out, I'm even closer, correct?
Yes.
If I'm lunging and going for your gun, which is an extension away from your body, closer still.
Yes.
Perfect. He got in, going for your gun. Perfect. I would have.
And you saw the video that Dr. Jensen reviewed, and he was running, correct?
He was.
The wound in the back, when you talk about, I can get out to that word, anatomically correct position?
Atomic position, yes.
That's, as I'm standing here before you, standing straight, with you said palms forward.
Correct. Anatomic position.
Okay.
I think you had me doing it.
Okay. And the wound enters his back,
That's correct.
okay, and goes down and across.
Correct.
Okay, we're not, and I know the prosecution covered it, but we're not saying that he was turned and shot in the back, correct?
That's correct.
There's nothing in the hand shot that shows him, would lead you to believe that his hands are up like this surrendering, correct?
That's correct. I did not see that in the video.
And your theory or your belief to a reasonable degree of medical certainty is that he's in a horizontal position close to my client. The bullet goes in and across and down.
That's correct.
Okay, so once again, in the position of lunging would put you in a horizontal position, correct?
It would.
And there's some stippling to the wound in the pelvis, correct?
Yes, to the lower abdomen above
Okay,
it.
and that's not trying to, but there, it starts at the belt line and goes up, correct?
That's right.
Okay, and as it starts at the belt line and goes up, the reason it's not below the belt line is because he was wearing pants when he was shot, correct?
Yes, that's right.
Okay, so it's what he's doing good here is he's pointing and showing and giving a realistic view versus the other guy was just talking and letting the doctor explain. He's letting the juror understand and giving them pictures. People, remember, if you see something, nonverbal communication is 75 to 80% of communication. So what you're doing, facial expressions, movements, pointing, people hear more visually than they do what you're actually saying.
And that was gunpowder stippling.
That's correct.
Okay, so that's basically 1 foot to 4 feet.
Yes.
I like the way the doctor isn't getting offensive. He's not getting argumentative. He's not getting butthurt. Because, see, he's not attacking anything the doctor said. This doesn't change the doctor's opinion. So that's why this is such a great cross right here.
And hate to jump around here, but the wound on Mr. Huber, I'm assuming at some point you pulled off that bandage that was on the wound?
Yes.
Okay, now, was there stippling on that wound?
There was, yes.
Okay, and that wound was what kind of stippling?
Gunpowder stippling, so that wound has the impacts from the gunpowder particles,
Okay.
a more dense distribution.
Did you look at the clothing around the wound?
On Mr. Huber?
On Mr. Huber?
Yes.
Okay, and the clothing also had gunpowder residue?
A little more difficult to say on the clothing. Mr. Huber's tank top, which was the item of clothing that came with him, that tank top it was a tie-dyed black and gray and white appearance. So,
Yeah, so that's going to cover up any mild burning or color changes caused by the gunpowder. That's a great way to explain that.
made that very difficult. So in those situations, usually I will defer to try to opine if I can't tell for sure.
Okay, so there's nothing in that gunshot wound that suggests that he wasn't in close contact with my client's firearm.
That's right.
Okay, and did you look at any video regarding that shooting?
Yes, it's also included in that video provided.
And the video shows that my client's lying on his back, correct?
Yes.
Mr. Huber grabs.
See, instead of lying on his back, my client was knocked down on his back. You see the difference between those two? You want to make your client the victim. And these attorneys are not doing that as well as I would like. They're not doing a horrible job. But phrase it the way you want the jury to hear it. My client was aggressively knocked down. He was being attacked and knocked backwards and fell onto his back from the aggressive acts of the crowd. Explain it instead of he was on his back.
Grabs the firearm, correct?
It appears so, yes.
Pulls the firearm from one direction towards and into his chest, correct?
They end up in that position. I don't know if he's pulling or what. I don't know what's going on there.
Mr. Huber strikes him with the skateboard. The gun is not in his chest. Fair statement?
That fair statement.
Okay. When he's shot, the skateboard is in his right hand. The gun is now up in his chest.
Or Jeff, these are conclusions based on
I'm asking if his wound is consistent with this scenario.
Wait, finish your question.
Okay. I'll start over.
So see, he was getting on a roll with this guy. And what happens when you start getting a witness to agree with you and he's asking and there's this quick change of question, answer, you want to break that up. So this objection, he doesn't really care about the objection. He didn't care that he lost. He changed his train of thought. He messed up his rhythm and now he's got to get back on track. So that was a calculated objection to slow down his rhythm.
Mr. Huber, you see him hit my client in the head with a skateboard, correct?
Yes.
And
The objection.
These are conclusions that Mr. Huber can't or did anything is central in this case. These are not conclusions that anyone can make of the jury.
He said, the doctor said he watched the video, and so I'm assuming that that's his knowledge base. And you can redirect on the subject if you want.
I'll start again, sir.
For the third time. You see him smiling? He's like, I got him. I'm messing him up. He can't go with his flow. he's completing his goal and this guy's letting him do it. But it's hard when he's fighting for his client right here. He's all focused on his thing. He's in a rhythm, and he doesn't like this guy messing it up, changing his train of thought. Now he's got to go for the judge. Now the judge told him it's okay, and now he's got to get back on track. But he accomplished his goal.
There is a blow from Mr. Huber to my client's head with a skateboard, correct?
Yes, the skateboard makes contact with Mr.
He swings the skateboard with his right hand.
I'm surprised he didn't object and say, let him finish. I'm surprised the court reporter didn't say, don't interrupt him, let him finish before you start. Did you see that? When you're on a roll and you get going, you start wanting to get your point out so quick. He kind of overrode the witness's answer. Let's go back to that.
With a skateboard, correct?
Yes, the skateboard makes contact with Mr.
He swings the skateboard.
See? He cut him off and didn't let him finish. I'm surprised the prosecution didn't object and say he didn't finish.
With his right hand into my client's back neck range, correct?
I'm not sure where it makes impact, but
You see an impact.
yeah, it makes contact.
And he reaches down with his left hand, seeming to grab my client's gun, correct?
Yes.
When he puts his hand on the gun, the barrel is not pointing in his chest, correct?
I don't recall, but I don't think so.
Okay. And through whatever movement between my client and Mr. Huber, the gun barrel ends up, which would be right about here.
It does.
Okay? And there's a gunshot, correct?
Yes.
And that gun is touching his clothes.
It's in intermediate range. It's
So,
closer.
and define intermediate range for.
Well, see, he keeps trying to get him to give definitive answers, and it's not that you want a definitive answer from him. You just want him to agree, and you want to get out in front of the jury so they can hear you explaining. I mean, it doesn't matter what difference does it make whether it was in touch of his clothes or not? It was in close proximity. Okay, we get it. I mean, he described it. He got his point across, but he's reaching too far trying to get the doctor to make a conclusion. This doctor isn't going to make that conclusion because he doesn't know. And then he loses points when the doctor disagrees with his questioning. Stick to the ones you got some good answers. Don't try to get more that the doctor doesn't know.
For me, please.
Well, again, we've talked about how intermediate range injuries can be within 4 feet, but it obviously from the video it's closer than that. But I can't say whether the muzzle was in contact with
Okay.
his
But
clothing.
through the type of stippling that you have on the Huber wound, you know it's less than 4 feet. Fair statement?
That's a fair statement.
Through independent evidence, which you review as a forensic pathologist / investigator, the video evidence establishes closer.
It does.
Okay, so he cleaned that up pretty well. He backed up. He gave simple things, got the answers he wanted, and cleaned it up. That's what he's supposed to do.
And just assume, for the purposes of this question, that
Oh, I'm surprised they didn't object. Why are you getting him to assume?
the first shot from my client, moving back to Mr. Rosenbaum now, is the 0 shot, number 1. The fourth shot is 76 hundredths of a second after that. That is how fast 4 shots were fired out of my client's gun. And he goes from the furthest 4 feet to touching the gun, correct?
Yes.
That calls for speculation.
Doctor answered yes. Overall.
And you're opining regarding the order of
Anytime you get overruled, I like when attorneys re-ask the question to get the answer just to piss the DA off. And because of the objection and the ruling, sometimes the jury misses the point because they hear objection, they shut off the answer and they don't remember it. So I like when attorneys re-ask the question and get the answer again. Not only does it piss the jury off, but it reaffirms that you're allowed to ask it, and I want to make sure you heard his question. If they're objecting, they don't want the jury to hear it. So once you get and win that objection, make sure the jury hears it again.
shots. Is that to a reasonable degree of scientific certainty or medical certainty? I apologize.
Medical certainty, as I pointed out, from the autopsy findings alone, you can't put these in order. It's only by reviewing the video and simply looking at the orientation of his body and comparing that to the findings on the body that you can do that. So to that degree of certainty, it appears that he's in that horizontal position.
And Mr.
It's an educated guess based on the facts, your training and experience, that what you see, this is an educated guess that I'm giving. It's an opinion. It's not fact.
Carlos asked it, the shot to the pelvis, you think is first?
I think that makes the most sense.
Okay. The shot that goes in the scalp, second?
No, I think that the only orientation that makes sense with the trajectory of the gunshot wound to the back and the right side of the head is when he's in more of a horizontal position. So those two injuries must be the third and the fourth injuries. But that's the best I can do.
The head wound goes back to front and from the top of the head down towards the forehead.
That's right.
Okay, so if I was charging like a bull and diving, that would be consistent.
It would be.
I have nothing further.
Right.
That was his last question? Okay. They're going to redirect for sure because he made too many points that he wanted, so they're absolutely going to come back with more questions. Even if it's a bullshit question that he's already answered and asked just to kind of, make themselves and him look like he didn't get beat up.
Doctor, the injuries you noted, they'd also be consistent with falling after being struck in the hip?
Yes.
So if Mr. Rosenbaum was struck in the hip, his momentum kept carrying him forward, he was falling, the other 3 shots could have been as he was falling.
That's possible too.
But it's consistent with that.
It is.
Well, now see, he said it's possible. Objection, Your Honor. He answered it was possible. And the attorney just said, what did he say? I can't remember now. But he changed his answer. He said it's possible. I'm okay with that. But the prosecutor wanted more and he changed it.
Shots could have been as he was falling.
That's possible too.
But it's consistent with that.
It is.
So he said it's consistent. Well, he also said it's possible.
What is a muzzle stamp?
Well, a muzzle stamp is what we briefly talked about earlier with contact gunshot wounds. And if the energy of the bullet entering the body causes the skin to smack against the muzzle of the gun, it can leave an abrasion, even a patterned abrasion in the shape of the muzzle of the gun on the skin. And so a muzzle stamp is a term that's used for a contact abrasion that's associated with a contact gunshot wound. And the reason why when we talked about a close range wound to the hand, the reason why we didn't talk about that, although it could be in close range like that, is because the skin of the palm is much thicker, and it very seldom, if ever, allows for a muzzle stamp or an abrasion of that sort. Certainly not like you would see with a contact wound to the head or to the chest.
So
I'm not sure if y'all understand what a muzzle stamp is. This is like a muzzle break of the pressures and the gas that this gun was very close to this injury. This is a different muzzle stamp to where you can see the muzzle and the burning almost of the barrel as it hit. And in this one, you can see the barrel compared to the burning or the sizzling where it was pretty close shot.
Of the palm is much thicker, and it very seldom, if ever, allows for a muzzle stamp or an abrasion of that sort. Certainly not like you would see with a contact wound to the head or to the chest.
So there was no muzzle stamp in this case?
No.
Okay, I'd like to ask Investigator Stu to pull up Exhibit
He kind of shot by that quick, so there was no muzzle stamping.
41, but as we're doing that,
I think the defense should have wrote down, when the prosecution asked you, was there no muzzle stamp, that doesn't indicate that he wasn't close to the gun, correct? You can be close to the gun without getting a muzzle stamp because you're not touching the gun. Would that be fair to say? I would get that out just to defeat what he just did. Because he made that little comment, moved on like he wasn't that close.
if I'm holding a rifle, let's just say that I've shot you in the hip, how does it make sense that the gunshot to the hand occurs in the trajectory you've indicated?
So if this points in the direction. Oh, thank you.
Can you
Here's
stand back
Go
there?
ahead.
Sharing that microphone can pass corona. I'm surprised they're doing that. Wonder if you got to have a vaccine to go into court.
Palmar surface of the index and the middle fingers. The exit is to the side of the index finger. So obviously it's hard to do this completely, but it's like this.
Can't
So the
see
anatomy
this,
is
so I'm gonna
divided
bump forward.
in a position in which the hand was going down.
But the barrel would have to be behind the injury, correct?
Yes.
So the bullet would have had to travel outside of the barrel, so the barrel would have had to have been in front of or somehow separated from where the wound took place.
Well, that's what I said. I can't tell that. This is a close range wound with soot, but there isn't going to be a muzzle stamp because of the skin of the palm. So it's within that distance, but whether it's in contact or whether it's just in front of it on the entrance portion of the wound or inches away, that's not something I can tell you.
Swiping something away? Swiping a barrel away?
I can't tell you what he was doing at the time that happened. All I can tell you is that
Good.
at the time of the discharge of the weapon and the traveling of that bullet into his hand, this is the trajectory that it took through his hand. I can't tell you what he was
Good.
doing at the time,
Good.
and I can't see it on the video. The video's not good enough for that.
Isn't that what the prosecution objected to twice when he was trying to talk? That he was trying to get him to say some shit that he didn't know, but now they're doing it?
Exhibit 41, please. Could holding something in your hand, could that impact the wounds or the stippling or the soot or anything of that nature?
Yes?
You mean, well, I mean, if you're holding something in your hand and you're referring to some kind of something that's going to create an intermediary target or something,
barrier.
yeah, that can affect the appearance of wounds. You know, the injury might look very different in that case.
So when Attorney Richards was talking to you about the wound to Mr. Rosenbaum's left hand, and there's blood everywhere, and there's soot in many places, if he was holding, say, a handle of something, would you expect that the soot and the
A handle or something? You mean like a club or a chain or a rock? Hang on, I think he's objecting. I can't hear it.
holding, say, a handle of something, would you expect that the soot and the
There's been no evidence whatsoever that he had anything in his hand.
I agree.
Questions must be asked to a reasonable degree of.
And you notice his objection cleared it up for the jury. There has been no evidence of anything in his hand because they're playing these games. We have to make him look like he wasn't the aggressor and he was so they're just throwing shit up to confuse the jury, and he cleared it up and said there have been no evidence of anything in his hand.
Post-mortem autopsy certitude, would that be a fair way to put it?
I'm not really sure I understand the question.
You're not the first. You hesitated before when asked about medical certitude, which is a common expression we use in the courts, and I'm trying to see what degree of, how would you phrase the degree of certitude with which you would typically respond?
Well, I can testify to a reasonable degree of medical certainty when I'm using the autopsy findings and the meaning of those in reference to the injuries. I've seen the video. As I have testified, I discussed the video with regards to his position when I heard the gunshot wounds discharge. I can't really see what's going on in front of him at those times. So when the questions are going into those specifics, I don't think I can answer those from the video that I watched. So I think I'm trying to be careful not to evaluate that video more than I used it for, which is to determine what position he was in when
Great answer. Great answer. Good, credible dude.
those gunshot wounds were received.
Why don't you rephrase your question? What's required here for the state, certainly, but frankly for both parties, but is a degree of certitude to which the physician can testify.
The injuries and everything you testified to on the left hand, that's consistent with nothing being in his hand?
It is, yes.
Thank you.
He changed his answer. A few minutes ago, he was trying to imply that something was there. And he just abandoned it because he knew he was losing. He goes, well, are they consistent with nothing being in his hand? He said, yes. And he goes, I'll move on. So he tried to clean it up. Hopefully people paying attention caught that it's bullshit and their games they're playing.
I'd like to direct your attention to Exhibit 41. If you can tell, is this the video that you reviewed in terms of both the shooting deaths of Mr. Rosenbaum and Mr. Huber?
It is.
I'd ask you to play the video until I ask you to stop.
Hey!
Can you see where on there you indicate that he would be positioned with the first shot?
Yes, I can clearly see the reflection of light on his back, and I can see that he's upright when the first shot is heard.
So now the prosecution is trying to discredit their own witness because they think they're losing and he's helping the defense more than it is them. Man, you talk about freaking government. That's what I tell people. Even if you think government is your friend 1 second, they will turn and hang you out to dry. They are using you for their benefit each and every time you interact with government.
So that would not be consistent with the shot to the hand?
No, I think that's. I think that placing the hand in that position would affect the gunpowder stippling to his lower abdomen. So I don't think the hand is involved in that first shot.
So, to the best of your, so it's consistent that the first shot is to the hip,
That's what I think. Yes.
and the second shot would be to the hand,
Yes.
and then the
That's what I think. That's my opinion. That's what I'm guessing from the information I have. With more information, I may change my mind.
third or fourth shot. Can you order those any more specifically?
No.
But they would be as he's in a horizontal position, perhaps falling after being struck in the hip.
That's right.
Let's show Exhibit 86, please. Deposit. Large amount of smoke that was emitted from the gun.
Yes.
Now, with that amount of smoke out of an AR-15, would that impact how far the stippling may occur?
Would the smoke impact?
The larger amount of smoke. Would the stippling go further out than the 4 feet?
No, I don't think there's not a relationship there. The stippling is the gunpowder particles that are flying through the air and dispersing as they travel. The smoke is the smoke and soot.
I think the smoke, the large pattern, indicates that he was closer and he was obstructing the smoke from going forward, and it was bouncing off his body, and it was taking the path of least resistance, which was up and to the left, which made it look bigger. Had he not been close to the barrel, the smoke would have been more as a tube, like it does if you're at a shooting range or shooting a gun with nothing in front of you. Maybe the defense can bring that up.
From the barrel of the gun.
Does the amount of gunpowder matter in the stippling?
Well, yes.
I'm sorry, go ahead.
Well, I was just going to say it does. I mean, there's.
The farther away it is, the probably less you're going to have. The closer it is, the more you're going to have, because it dissipates and it loses velocity.
The number of gunpowder particles that leave the barrel of the gun are not predictable, certainly, but they will travel in a dense group and then disperse as they get farther away, with more and more falling to the side until none have the energy to create stippling to the skin.
Now, when you see that large puff of smoke, you said that would be that is what would potentially soot on an individual.
My presumption is that that puff was the smoke and soot from the end of the gun.
So with that large amount of soot, would it be possible to deposit soot further out than just a few inches?
I don't know if I can answer that question. Test firing the weapon, you might be able to derive more information, but certainly soot's not very aerodynamic. It doesn't travel very far.
Now, Attorney Richards did a demonstration with you where he stood about 4 feet away and talked about the intermediate range. Now, we're in talking about intermediate range, you're talking about feet from the barrel of the gun, not from the shooter.
I think he's going outside the scope of the redirect, because I don't think he brought that in. He's just kind of rattling now. I think the defense has an objection here that he can't be going off to other areas that wasn't addressed in the cross.
Correct. To be specific, the injuries that we're talking about are from the barrel of the gun to the surface that they make impact with, so the surface of the body in this case.
When the prosecution is attacking their own witness, you know they're freaking losing. And they know it.
And you haven't seen the actual weapon in this case, have you?
No, I have not.
Oh my God, we got to bring the weapon in. See, the more times we put the gun, the mean, scary AR in front of the jury, the more we can get them. Every chance they have to get. How is him seeing the gun changing a damn thing about his medical autopsy and what we're talking about?
So I'm going to ask Detective Attorney to point the gun at me.
Check it again. Yeah. Check it again.
No need. So if he was to point the gun at me, I'd have to be 4 feet from the barrel of his gun, or 1 to 4 feet to generate the stippling you're talking about?
Inside of 4 feet, like I said, that's an outside number.
Is that approximately where I would be right now?
It's about 4 feet, maybe a little closer.
I'll get a ruler. That's more than 4 feet.
It would be my impression that it's a greater distance than 4 feet.
Well, I'm not bad at distances. Is it 4 feet approximately?
It's a little hard to tell, but you're closer. You're probably about 4 feet there.
More than one of my arm's lengths anyway?
More than one of your arms length.
Thank you.
Request?
Okay, so that's not good that he's kind of, it's almost like he's smiling or taking this as a joke or not serious. That's why they're freaking showing his face, because they, you know, everybody, media, everybody's against this kid. Nobody's on this guy's side. So any chance they can show him doing something so they can plaster it on the air later, they will. I mean, I know he's only 18, but I mean, somebody needs to get a hold of him and go, dude, I don't want you freaking smiling at this freaking trial again.
Doctor, the soot is within 6 inches, correct? The soot stippling?
Oh, the soot. Yeah, the soot is within inches.
The intermediate gunpowder stippling is within 4 feet.
Approximately, yes.
And if the first shot is... You can hold it.
Oh, so they finished. Man, he just took that gun. I gotta go back. Look at the face on the detective.
If
What
the
the
first
fuck?
shot is... You can hold it.
He ain't got no gloves on. He's like, oh shit, what do I do?
Here, detective. Keeping it down. If this is the barrel of the gun, and the 0 shot is the first shot, and
So now he's putting gloves on, like it matters.
somewhere from, and I'm not as good as or as bad, I don't know, but let's say this is about 4 feet from the barrel of the gun.
Somebody pull out a damn ruler already.
It's a little farther than 4 feet.
Okay, so I mean a little bit further. But from the furthest he is, would be 4 feet. He could have been as close as here with the first shot, correct?
Possibly, but the density of the gunpowder stippling it's pretty spread out, so I think it's a little further away.
And I'm using my right hand because I'm...
See, because you don't know what you're talking about, you're going to hurt your own case right here. Because you're playing stupid games and bullshit. This guy was your witness. You ended good. Quit trying to make it better because you're going to fuck it up.
No.
You know, these gloves got into court here about 10 years ago, and I understand there are appropriate times to use them, but not everything that...
I don't know why I'm using it.
I don't know why you're putting a glove on, to be honest with you. You're not going to get the cooties from that.
No, I agree.
All right.
Yeah, I don't know why he's putting a glove on either. I don't know why the guys are. I was like, why are you guys putting gloves on? You've already tested it. You got DNA. It's been contaminated. 100 people have used it. Now, why are you putting gloves on? Does it make you look important? Does it make it look like you're really doing a good job about preserving evidence, even though you didn't even test the damn barrel?
So
Well, what difference does it make? It's
the end of the gun, touching with my left.
Kyle, I'm going to slap the shit out of you if you smile again. Knock it off. Somebody ought to have a damn shot collar on his ass and zap him every time he does something inappropriate with his face. He's happy because he's winning and he knows he's making points and he knows they're looking stupid and he knows that they're lying. And so he's happy and that's normal. But you do not want to do that in front of a freaking jury.
Left hand, like this. The heavy soot is right here.
You're with your right hand, but yeah,
The heavy, see, then I got to go to the other side.
Yeah, you have to
Sorry.
turn around.
Can you switch with me? So if it's the left hand, we're going to go like right. Can you see this, doctor?
You actually have to turn your hand.
See, the other attorney ought to sit down and say, Kyle, have a seat, and whisper in his ear, dude, you're showing too much emotion right now. Lock it up. Have a straight face. Look like this is serious. Your freaking life's on the line. And if you're smiling, it could be the difference of you going to prison for the rest of your life. So knock the fucking smile off your face, and I don't want to tell you again. I'd be in his freaking ass.
And over.
Over, like
And
this?
no, go the opposite direction, like this.
Like,
There you go.
okay. And it would then come in approximately here.
That's the entry point to the hand, yes.
Exiting where I'm playing with my hands here.
Correct.
And the reason there's no soot stippling here is because it's past where fire comes up.
I can only say that there's no soot there.
Okay, there's no soot. Okay.
I know these people are here for news purposes, the photographers, but I actually think for purposes of the record, I'd like them to come up and get a closer shot.
Holy shit. Really? Damn.
Am I positioning my hand correct?
I think so.
It would be more like...
Look at these freaking news reporters with their little cameras. Oh my god, I'm getting a picture. Let me get up here. I got my little mask on.
This is the exit point right here. Is that correct?
Yes.
Fucking show.
Just so the record's clear, my hand is touching the end.
Technically, the defendant, Kyle, has a right to see all this also, and he's back at the desk.
Your hand is now touching the barrel.
Okay. And if my hand were in front of the barrel, there would be soot here. And I'm pointing now to, what would you call this part, Max?
I would call it the outside of the pinky finger, so that it's understandable.
The outside of the pinky finger, if my hand was in front of the barrel, the heaviest soot would be in that location, correct?
You would expect soot in that location.
And
No, I'm sorry, but some of the jurors I don't think are able to see, so let's, you got your shot. So, you go ahead.
the pinky finger, once again illustrating, the side of my hand.
Tell him to quit fucking smiling.
If it was in front of the barrel, as it's now depicted, the heaviest soot would be here.
You would expect some soot on that side of the hand.
And there's,
And I didn't see it.
I don't know.
Would you send copies of those photos? Send copies of those photos to the.
I guarantee you tomorrow on the news will be Kyle smiling, thinking this trial is a joke. He doesn't care. He's immature. He killed these people and now he's laughing about it. You watch tomorrow.
Clerk, please. Send copies of those photos to the clerk. Thank you.
Oh, so the judge got evidence in. He told him to send copies of the pictures they took to the clerk.
So, doctor, is it consistent if I'm approaching the detective?
I have a feeling they have a dedicated camera on Kyle because when they go over to him, there's no spanning, there's no nothing. They can switch to him at any time. And every time he does that, they switch to him.
Struck in my hip, fracturing my hip, that I would fall.
You know, if I'm the jury and I'm like, you freaking attorneys and shit can't figure this shit out and you want me to figure it out, you guys have seen what we've seen and you want us to figure out this bullshit? I mean, the prosecution is just hating this because it's totally justifying that he was grabbing for the damn gun. Everyone knows it except the prosecution who's trying to lie about it.
Reach out with my hand and try to knock the gun away.
That's a possibility.
Am I positioning my hand correctly with the evidence?
Your hand is, you put your hand over
We don't know if it's over, so
this,
oh,
well, just in a position so that the soot is on the palmar surface,
like this?
like this. So if you go in and you,
So the entrance wound is here.
no, the entrance wound is on the palmar surface, the undersurface.
Palmar surface.
So if you do it, Superman, and then turn your hand a little bit like this, you can put it in a position that there you go,
Like this.
like that.
So what you're saying is consistent with being shot here, momentum carry forward, and swiping at the gun. That would be consistent with the injuries you found.
Those scenarios are possible.
But my hand is positioned correctly to.
You notice the cop is holding the gun and it's shouldered? I'm not sure Kyle had it shouldered when he did this. I thought it was lower. I have to go back and look, but I'm not sure he had the weapon shouldered like the cop is holding it, which changes. That's why when you get into these things, when you have video and you're not comparing it to the video and you're just ad-libbing and trying to do all this sneaky lawyer bullshit, all you do is confuse the jury and you negate the fact of getting to the truth.
Create the injuries that you found.
But that's the position that the hand has to be in.
And then the bullet would have traveled down and potentially kicked up some bullet fragments and concrete and hit my leg.
That's what I think happened.
And then it would have continued down and then the shot to the head.
Kyle, sit down. You don't need the center of attention.
As I was falling
You
down.
got enough
As you're more
attention on
horizontal
you.
to the ground, yes.
Thank you. Nothing further.
Doctor, when you get shot the first time, that doesn't cause you to go forward, correct?
It shouldn't cause you to go forward, backward, or
Okay,
anything.
so he already, Mr. Rosenbaum, already had to have forward momentum at a force to go from the zero shot to the second shot in 2.26 hundredths of a second to be in contact or right on top of that barrel, correct?
Yes, he had forward momentum.
I'd accept that and shut up and get out of there. That's a good answer to end on. Just leave it alone.
Thank you.
Nothing further. Nothing further.
Okay, thank you, Doc.
Thank goodness. Good grief. Okay, so it looks like there's going to be some sort of issue about the first witness that they're calling for the defense. So I don't know if the state arrested or not, but they're talking about the defense's first witness here.
Our first witness is Nicholas Smith. Mr. Binger has informed me that, and I guess I can let him tell you this, but that he has 2 juvenile adjudications. The year, can you tell me the years?
They're both from April 30, 2014 here in Kenosha.
So I don't know how last.
He
would have been 16. He is now 23.
Hand me the.
There have been other criminal cases since then.
The way that the district attorney is wiggling around like the slime ball he is, somehow I don't know what's going on with the witness. So what? He has some juvenile crimes. The guy's 23 now, and he's got other criminal cases. I have no idea why they're talking about this.
There were 3 or 4 pending criminal cases that were resolved with pleas, one to disorderly conduct and one to violation of a temporary restraining order. That was from April of 2016, and then in May of this year, both of those adult convictions were expunged.
Oh, he got both adult convictions expunged. Oh, maybe they want to bring him up to discredit him, and the defense is saying you can't because it's expunged. I don't know.
Okay, well, those are not going to count.
I understand that, but they're...
Your point that shows persistent lawless behavior. Give me the. I guess I have the ability to look at it.
I can give you the case.
Maybe the defense wants to bring it up because he's one of the idiots. I don't know. I didn't catch the name.
Numbers if you like. 14 JV 36.
Did you want to say anything? I'm going to count it as 2.
So the question is, have you ever been adjudicated delinquent, not convicted of a crime, right?
Right.
Okay.
All right.
Just so... You understand that? Okay. And that's the only thing you answer is that number.
Okay, ready to go?
I'm ready.
Okay. Yeah, please do. Would you come down, please?
Yes.
Maybe they're waiting for the jury to say the
let me
defense
see.
rests.
I'll come back and a couple of things. First off, there was testimony given by Brandon Kramen, an employee of the FBI, which was incomplete. It was interrupted, and because it was interrupted, it wasn't heard in full, and for that reason, I'm going to strike all of that testimony, and you must disregard that entirely.
Oh, that's one of the things that we didn't get to see. We didn't get to see the FBI agent testifying. Secret courts. Anytime the FBI is involved, you know there's dirty shit going on. It's the KGB of this era.
Any question about that? Okay. Number 2, the 7th count of the information accused the defendant of violation of a curfew, and that case is no longer part of the action here. So the information remains with 6 counts in it, and I'll instruct you further on those at the close of the case. But the 7th count of curfew violation is no longer part of the contest here. Okay. Thank you, Mr. Binger.
So I'm kind of wondering why they threw out the curfew violation. Was he not in a public place? Was he on private property? Because they didn't charge the other guys with curfew? I'd like to know why the prosecution decided to dismiss that. What's that called? Is stacking charges. When you add a bunch of charges for the jury reads the charging list and went, oh my God, this guy's horrible. Look at how many charges. And then as the trial goes on, sometimes the prosecution will go, we're going to drop that one. We're going to drop that one. They had no intentions of going after it. They just wanted to make you look bad at the onset with all these extra charges. Now, curfew violation is probably the least of his problems. Of course, that's the one they dropped, and I don't know why.
Your Honor, the state formally rests its case.
Okay. Thank you.
I was waiting for that. I was like, damn, why did he say he rest? Okay, so they rest. That is the case. So right now, and this is a key factor, right now, the jury, if they had to vote, would they vote guilty or innocent? If I'm on that jury, there's no way he's guilty. But right now, the defense has the absolute right to say, we are not putting on a defense. The defense rests. And they don't have to call one witness, and they don't have to say one thing. They can and I've seen a couple trials that do this, and you know you've put on a shitty case when the defense goes, you know what, your case is so shitty, I ain't even got to open my mouth and possibly screw it up. I'll let the evidence sit as it is. Now, because this guy's facing life, and this is such serious charges, they're not going to do that. But they have that right to do that, and if you were on the jury, do you think the prosecution has convinced you beyond a reasonable doubt and above a moral certainty that this kid is guilty of everything they said he is. To me, they didn't even get close. That doesn't mean the jury won't convict on it. I'm just saying to me. All right, I'm going to end this here. We'll make this part 2, and I'll start on the case for the defense.